Did you see any interesting trends that either developed or continued from previous sessions?
Well, there is a great deal of unanimity on the court. I mean, this is kind of an increasing trend over the last number of years. It goes into what John Roberts has said, that he wants the court to speak with more of one voice. But here, in part, as I mentioned, President Obama has succeeded in creating bipartisan unity with a record number of unanimous votes against him. And indeed, overall, the government has been losing much more than it has historically. But on the unanimity front, this term, about 2/3 of the cases were decided 9-0, which is a modern high, not seen since 1940. You take another handful of cases that were decided 5-4. That gets us over 50%. Over 80% of the cases were either unanimous or hopelessly split 5-4. So it shows you that the cases, at least that the court is taking, are either really simple for the court to resolve, or at least they take narrow decisions that more people can agree upon, or they're hopelessly split, like in the civil rights area.
That, I think, would surprise a lot of people to hear that there is so much unanimity when all you hear in the mainstream press about the court is that you've got a conservative wing and you've got a liberal wing, and Anthony Kennedy can go either way. It doesn't sound like that's the way they really operate.
Well, most of the cases you never hear about. The bankruptcy law, tax code, ERISA, criminal sentencing, a whole host of very, very technical issues that sometimes the lower courts are split on or simply get badly wrong, and the Supreme Court doesn't have much of a problem resolving it. Some of these cases that have been unanimous, some commentators have called phonanimity, in the sense that, yes, at the end of the day, all of the justices agreed on which side won, but there were harshly worded concurrences that were dissents in all but name, and Justice Scalia authored notable ones, including in that recess appointments case, Noel Canning, in an abortion clinic buffer zone case called McCullen. In these cases, the concurring justices, sure, they agree in the judgment, but they don't agree with the reasoning, and they would have gone much further than the majority would. So there is a bit of that. But even in cases where all justices agreed on everything or on most things, still we have a record number, a record level of agreement. In part, that's generally a good thing, I'd say. But in part, it's because the court here's another trend, declining a lot of the interesting and important cases that I think it ought to, in areas such as Second Amendment, federalism, certain First Amendment doctrines as they apply to broadcasters. There's a lot of very interesting areas that are frustrating, even more than the decisions that I would characterize as overly narrow. But the dog that didn't bark, the cases they didn't take, are also a big story.